Hello, hello. Today we are going to go over the CAR form CC, cancellation of contract, comma, release of deposit, and cancellation of escrow. The reason I'm emphasizing these last few things is because this is not just a cancellation of contract. We're also releasing the deposit and we're canceling escrow all in this form. So it's hyper important that you stay tuned and pay very close attention. It's so important that I took notes on this side, so you'll see me looking over here as well. Let's go ahead and get share screen going here. Okay, fantastic. You should be able to see this screen over here. Let's make sure that was the right one. And desktop one. Yep, was the right one. All righty, cool. Okay, so this form was revised in 2021. Make sure that you guys are using properly dated forms. As you can see, this is terms and conditions to the purchase agreement or other. Make sure that when you're filling this out, this form, that each one of these boxes is labeled properly. That is huge so that you don't get escrow confused. All right, cool. Let's go through section 1. Paragraph 1 here. The RPA gives either buyer or seller the right to cancel the contract unilaterally if the other party has not performed to some obligation of the contract. Make sure to check out paragraphs 14B, C, and D of the RPA to research this further. Essentially, paragraph 1 of this form allows the buyer or the seller to give notice to the other that they want to sell based on they want to cancel based on the other party's failure. The form may also be used if the buyer and seller want to mutually agree to cancel for whatever reason that may be. So here you'll want to make sure that you state exactly who is canceling, buyer, seller, or both, and the exact paragraph in the purchase agreement that it's stated. Or as you can see here, you have different options. And then make sure that whomever is canceling signs here. Then you'll come down to item number 2, paragraph number 2, release of the deposit and cancellation of escrow. All righty. So although the right to cancel the contract may be unilateral, the right to have the funds released from escrow requires mutual consent, or the escrow can continue to hold on to that deposit until ordered to release it by a court judgment or an arbitration award. In paragraph 2 of this form, you can see that the deposit is also included in here. Right there where my cursor is. There are 4 options present. Option 1 is that the seller releases all the funds to the buyer based on paragraph C1. Option 2 is that the buyer releases all the funds to the seller based on C2. Option 3 is that the buyer releases some of the funds to the seller and that the buyer and the seller agree that the contract should be canceled, but they're authorizing the escrow holder to continue to hold on to those deposit funds until receiving mutual instructions by some legal authority. So that's what you can see here as I set option 1 here, option 2, option 3. You'll type in the deposit amount here. It is absolutely critical that you write down the correct escrow number here and who the title company is here. All right, keep on trucking here. Okay, if the contract is validly and unilaterally canceled, but escrow is not mutually canceled, that tricky, right? The seller may legally be allowed to sell the property to another buyer. However, if the title and escrow company holding the funds between the seller and the buyer, right, if they canceled the buyer side of the contract They will not usually agree to act as the escrow holder on a subsequent transaction between the seller and a different buyer. So the title company will stay on with this buyer, right? The one that's in contract now. But if the seller comes in with a different escrow, they usually will opt out of that escrow and just hang on to this one. The seller can also consider making the second buyer in the contract contingent upon the successful cancellation of the first contract. If the buyer will not sign the mutual cancellation by the time that the second contract is supposed to close, the second buyer, after consulting a lawyer, after consulting a lawyer, may then waive that contingency. As you can see here, it is critical that you guys make sure that you write down the exact information and that you slowly explain this to your client. That is the cancellation of contract. Here's the tricky thing, okay? You'll send this to the party canceling the contract, okay? Then you send it to the escrow company with this information, right? You want to make sure that you CC the escrow company and the other party, the listing agent or the buyer's agent, depending on who you are assisting. Hope this was super helpful, and don't you worry, just because this one has canceled doesn't mean it's the end of the world. Cancellations happen more often than we think. Deep breath, you will get through it.